The moment Karen Thompson smirked at my 73-year-old mother across the courtroom, I knew we were witnessing the beginning of her downfall. Your Honor, while I sympathize with Ms. Mitchell's age-related confusion, the Oakwood Gardens HOA bylaws are quite clear, Karen said, emphasizing age-related confusion, with a theatrical pause that made several people in the gallery shift uncomfortably. Her designer suit and perfect blonde bob screamed suburban power, but it was the condescension in her voice that made my blood boil. My mother, Sophia Mitchell, sat beside me, back straight, hands folded neatly on the table, her expression betraying nothing. Only the slight tightening around her eyes told me she'd registered the insult. After 22 years on the bench of the state superior court, my mother had developed an unparalleled poker face, a poker face Karen Thompson knew nothing about. I'm Emma Mitchell, 45, an environmental lawyer who moved back to my childhood town of Millfield after my father passed away last year. Mom had insisted she was fine living alone in the family home, but after she slipped on ice and broke her wrist in February, we agreed that downsizing made sense. The single-story condo in Oakwood Gardens seemed perfect. Well-maintained grounds, proximity to her friends, and most importantly, no stairs or icy driveways to navigate. What the realtor neglected to mention was that Oakwood Gardens had recently experienced a regime change. The once reasonable HOA board had been taken over by Karen Thompson and her slate of candidates, who ran on a platform of property value protection and community standards enhancement. Within 3 months of the election, violation notices had increased 300%, and the previously friendly community had become a battleground of compliance letters and anonymous complaints. Our troubles began with a bird feeder. Mom had always loved watching cardinals in the morning, so I installed a simple cedar feeder outside her kitchen window. 3 days later, a violation notice appeared on her door, unsanctioned exterior fixture installation. Reference bylaw 7.3a removed within 48 hours or face a $100 fine. When I called the HOA office to explain that the bird feeder was temporary and attached to a removable shepherd's hook, not mounted to the building, I was informed that all landscape modifications require prior board approval and directed to submit a formal application, which would be reviewed at the next monthly meeting in 6 weeks. This is ridiculous, I told Mom. It's a bird feeder, not a swimming pool. She smiled that slight, knowing smile I'd seen countless times growing up. Rules are important, Emma, but so is reasonable application. Let's follow the process. So we did. Mom completed the 4-page application, included a photo and diagram of the feeder's placement, and I hand-delivered it to the HOA office. The secretary, a nervous woman who refused to make eye contact, stamped it received, and added it to a precarious stack of identical forms. 2 days later, Karen Thompson herself knocked on Mom's door. "Mrs. Mitchell," she said, not waiting for an invitation to step inside, "I understand you're new to Oakwood Gardens, so I wanted to personally welcome you and discuss a few concerns. My mother, ever gracious, invited her in for tea. I sat at the kitchen counter, pretending to work while listening to Karen deliver what amounted to a kindergarten-level orientation to HOA living. You see, in a community like ours, uniformity is key to maintain property values," Karen explained, as if addressing a child rather than a woman who had once presided over a $200 million class action lawsuit. "Your bird feeder application will likely be denied because it creates an inconsistent aesthetic on the eastern-facing units." "I see," Mom replied mildly. "And which bylaw specifically addresses bird feeders or shepherd's hooks?" Karen blinked, momentarily thrown. "Well, bylaw 7.3a clearly states that exterior modifications." "I've read 7.3a, Mom interrupted gently. "It refers specifically to permanent fixtures attached to building exteriors. My feeder is freestanding and temporary. Might it fall under landscaping guidelines instead?" Karen's smile tightened. "The board has broad discretion in interpreting the bylaws, Mrs. Mitchell. That's why we were elected." "Of course," Mom nodded. "I'm simply trying to understand the parameters. In my experience, clear communication prevents misunderstandings." "Your experience?" Karen's perfect eyebrows arched slightly. Were you on an HOA board before? No, Mom replied, taking a sip of tea. Just trying to be a good community member. After Karen left, promising to personally review the application, I turned to Mom with disbelief. You didn't tell her you were a judge for over 2 decades, or that you literally wrote a paper on property law and community governance that's still taught in law schools. Mom smiled. It wasn't relevant to the conversation. Not relevant? She treated you like you were senile. People reveal themselves through their assumptions, Emma. Mom's eyes twinkled. Sometimes it's useful to let them underestimate you. I should have recognized that look. It was the same one she wore when facing particularly difficult attorneys in her courtroom. The calm before a judicial storm. But even I didn't anticipate how quickly things would escalate, or that we'd end up facing Karen Thompson in an actual courtroom just 3 months later. The bird feeder was just the beginning. Though Mom's application was eventually approved with strict conditions about seed containment and cleaning, it seemed to mark us as targets for Karen's particular brand of HOA enforcement. Next came a notice about Mom's welcome mat being non-standard issue. Apparently only black rectangular mats were permitted, not the colorful Welcome Friends mat I'd bought her. Then a warning about excessive holiday decoration, when Mom placed a small ceramic pumpkin by her door in October. The pumpkin was removed, only to be replaced by a violation notice for barren entryway presentation a week later. They're contradicting themselves now. I fumed, pacing Mom's living room. First, you can't have decorations, then you have to have decorations. Mom sat calmly in her armchair, reading glasses perched on her nose as she reviewed the latest notice. The specific language is interesting. Barren implies neglect rather than minimalism. I wonder if this is a standard form letter, or if Karen is crafting these personally. Does it matter? It's harassment either way. Intent always matters, Emma. You know that. Mom set the notice aside. I think Ms. Thompson is testing boundaries. She's established control over the community and now needs to maintain it through consistent demonstrations of authority. You sound like you're analyzing a hostile witness. Old habits, Mom smiled. Why don't we attend the next board meeting? It might be enlightening. The monthly HOA meeting was held in the community clubhouse, a beige room with uncomfortable folding chairs and fluorescent lighting that hummed just enough to give me a headache. About 20 residents attended, most looking resigned before the meeting even began. Karen sat at the center of the board table, flanked by 4 other members who, I would soon learn, rarely spoke or voted in opposition to her. She ran the meeting with military precision, cutting off questions, dismissing concerns, and repeatedly referring to the bylaws without actually addressing residents' specific issues. When the floor opened for community comments, Mom raised her hand. Karen pointedly called on 3 other people first, but eventually acknowledged her with a tight smile. Yes, Mrs. Mitchell. Briefly, please. We're running behind schedule. Mom stood, her voice clear and measured. Thank you, Ms. Thompson. I've been reviewing our community financials as posted on the HOA website, and I have a question about the recent expenditure for landscaping. The approved budget was $45,000, but the actual expenditure was $72,300. Could you explain the variance and whether it was approved by a special board vote? A ripple of murmurs spread through the room. Karen's smile froze. HOA finances are complex, Mrs. Mitchell. The additional expenditure was for emergency services after the spring storms. It was within the board's discretionary spending authority. I see. Mom nodded. And could you direct me to where that discretionary authority is outlined in the bylaws? I've read them thoroughly and found spending limits capped at 10% without membership vote. The room fell silent. One of the board members, a nervous-looking man with thinning hair, shuffled through his papers. We can address specific financial questions after the meeting, Karen said firmly. Next comment, please. But the damage was done. Other residents began asking financial questions, and the meeting that was supposed to end at 8 stretched until nearly 10 as Karen tried to maintain control of the increasingly restless crowd. As we walked home in the cool evening air, I nudged Mom's shoulder. That was masterful. You got everyone questioning the landscaping budget now. It's not just the landscaping, Mom said quietly. Did you notice the new security cameras around the clubhouse? Or the fact that the landscaping company, Summit Green, isn't listed in any local business directories? I hadn't noticed either of those things. Summit Green is owned by Karen's brother-in-law, Mom continued. I did some research after receiving their promotional flyer in our welcome packet. The company was formed just 8 months ago, right after Karen became HOA president. Are you saying she's funneling HOA money to her family's business? I'm not saying anything definitive yet, but I am curious. The next day, a new violation notice appeared on Mom's door. This one cited community disruption and spreading false information, and referenced a rarely used bylaw that prohibited activities detrimental to community harmony. The fine was $250. This is blatant retaliation, I said, already reaching for my phone to call the HOA office. Don't call angry, Mom advised. Document everything, and let's look more closely at those financial records. Over the next few weeks, Mom methodically built a case like she was preparing for trial. She requested all HOA financial records for the past 3 years, correlated board meeting minutes with expenditure approvals, and even enlisted her old friend Olivia, a retired accountant who also lived in Oakwood Gardens, to help analyze the patterns. What they found was troubling. Shortly after Karen's board took control, several long-standing service contracts were terminated and replaced with new vendors, all charging significantly higher rates. Summit Green Landscaping was just the most obvious example. There was also a new security company, cleaning service, and pool maintenance contractor, all with mysterious ownership structures and minimal online presence. When Mom tried to discuss these findings at the next HOA meeting, Karen cut her microphone and called for an immediate motion to adjourn, which her loyal board members quickly approved. The next day, an official letter arrived by certified mail. The HOA was filing a formal complaint against Sophia Mitchell for persistent violation of community standards and deliberate disruption of board proceedings. The letter included a notice of intent to place a lion on her property for accumulated fines totaling $1,450, most of which we'd never been previously notified about. This is absurd, I said, already mentally drafting the lawsuit I'd file against the HOA. They can't silence you with fake violations, and certainly can't place a lien without due process. Mom read the letter carefully, then set it aside with surprising calm. They're making a mistake, a big one. I agreed. I'll call Daniel at my firm. He specializes in property law. No need to involve your colleagues yet, Mom interrupted. I think I'll handle this personally. Mom, I know you were a judge, but you're retired now. Let me help. She patted my hand. Emma, dear, I may be retired, but I'm not helpless. Sometimes the most effective rebuke comes from unexpected directions. Her eyes had that familiar spark, the one that had made unprepared attorneys quake in her courtroom. Ms. Thompson wants to use the legal system as a cudgel. Let's see how well she understands the weapon she's wielding. That afternoon, Mom made several phone calls from her home office, speaking too quietly for me to overhear. When she emerged, she seemed almost energized by the conflict. We have a hearing date, she announced. 2 weeks from Thursday. County Court, Judge Bennett presiding. Bennett? I recognized the name. Wasn't he your clerk back in the day? He was indeed. One of my brightest. She smiled. Now I'm going to need my blue suit pressed and my case files from the garage. The banker boxes labeled HOA Precedents 2008 to 2012. Your father always teased me for keeping those. I think Dad would be enjoying this immensely, I said, already imagining how this would play out. He certainly would. Mom's expression softened at the mention of my father. He always did appreciate a good comeuppance story. The county courthouse hadn't changed much since I'd visited it as a child, tagging along with Mom on weekends when she needed to catch up on casework. The same imposing columns flanked the entrance. The same faint smell of furniture polish and paper permeated the air, and the same hushed reverence fell over visitors as they passed through the heavy wooden doors. What had changed was seeing my mother seated at the plaintiff's table rather than presiding from the bench. She wore her court suit, a tailored navy ensemble that somehow made her look both approachable and formidable, and had arranged her documents with the same meticulous precision she'd applied to her judicial calendar. Karen Thompson arrived 5 minutes before the scheduled hearing, accompanied by a young attorney whose nervous demeanor suggested he might be handling his first real case. She nodded curtly in our direction, but seemed confident, even smug, as she took her seat at the defense table. What she didn't notice was the subtle shift in atmosphere when my mother entered the courtroom. The bailiff, the court reporter, even the clerk all straightened slightly, their expressions warming with recognition. Mom acknowledged them with modest nods, as if she were simply a regular visitor rather than someone who had presided in these halls for over 2 decades. When Judge Bennett entered, the customary "all rise" was called, and I noticed Karen giving my mother a sidelong glance as Mom stood with practiced ease, familiar with the rhythm of court proceedings in a way Karen clearly wasn't expecting. Case number 2347B, Mitchell v. Oakwood Gardens Homeowners Association, the clerk announced. The Honorable Judge Bennett presiding. Judge Bennett, a distinguished man in his 50s with salt and pepper hair and reading glasses perched on his nose, glanced at the parties before him. His expression remained professionally neutral, but I caught the brief flicker of recognition when his eyes met Mom's. "Good morning, counselors," he began, then paused. "I see the plaintiff is representing herself. Please state your name for the record." "Sophia Mitchell, Your Honor," Mom replied calmly. "And you are qualified to represent yourself in these proceedings, Ms. Mitchell." A ghost of a smile played at Mom's lips. "Yes, Your Honor. I am a retired member of the bar and former judge of the State Superior Court." Karen's head snapped up, her expression shifting from contempt to shock in an instant. Her attorney dropped his pen. Judge Bennett nodded. "The court recognizes Judge Mitchell's qualifications. Please proceed with your complaint." Mom stood, her voice clear and confident. "Your Honor, I bring this action against the Oakwood Gardens Homeowners Association on grounds of harassment, selective enforcement of bylaws, retaliation for protected speech, and financial impropriety. I seek injunctive relief from unreasonable fines, plus damages." She then methodically laid out the pattern of targeted enforcement, producing a timeline of violations that correlated suspiciously with her questions about HOA finances. She presented affidavits from 5 other residents who had experienced similar treatment after questioning board decisions. Finally, she revealed the financial analysis showing the concerning pattern of canceled contracts and new vendors with questionable ownership structures. "Your Honor, the law is clear that HOA boards have a fiduciary duty to their members," Mom concluded. "When that duty is corrupted by personal interest or retaliatory intent, the courts have consistently intervened to protect homeowners' rights." Throughout Mom's presentation, Karen's expression had transformed from shock to outrage to something approaching fear. When it was the defense's turn, her young attorney stumbled through a weak argument about board discretion and the need for community standards, but even he seemed unconvinced by his own reasoning. Judge Bennett asked several pointed questions that suggested he found Mom's evidence compelling, particularly regarding the financial improprieties. When the attorney attempted to dismiss my mother's financial analysis as amateur speculation, the judge removed his glasses with deliberate slowness. "Counselor, are you suggesting that Judge Mitchell's analysis is less credible than your client's?" The same Judge Mitchell who presided over the Sanders financial fraud case, which I believe set state precedent for fiduciary malfeasance claims. The attorney blanched. "I wasn't aware of the plaintiff's specific background, Your Honor." "Perhaps you should have been," Judge Bennett replied mildly. "Due diligence is a cornerstone of effective representation." As the hearing progressed, Karen grew increasingly agitated, whispering furiously to her attorney and passing him notes that he largely seemed to ignore. Finally, during Mom's rebuttal to the defense's arguments, Karen stood abruptly. "Your Honor, this is ridiculous. She's just a confused old woman with too much time on her hands." Everyone knows HOAs have broad discretion in enforcing community standards. We can't have people questioning every decision. Property values would plummet. The courtroom fell silent. Judge Bennett's expression hardened. Ms. Thompson, you will take your seat immediately. You are represented by counsel and are not recognized to speak. Furthermore, you will show respect to all parties in this courtroom, regardless of age or any other characteristic. Karen remained standing, her face flushed. This is clearly a biased proceeding. You and her. She gestured dismissively at Mom. Obviously know each other. I demand a different judge. Ms. Thompson, Judge Bennett's voice could have frozen fire. You are in contempt of court. Bailiff, please escort Ms. Thompson to the holding area until she can compose herself appropriately for these proceedings. Counselor, you may continue without your client present, or we can recess until Ms. Thompson regains her composure. As the bailiff approached, Karen seemed to suddenly realize the gravity of her mistake. Her defiance crumbled, replaced by stammered apologies that Judge Bennett acknowledged with a curt nod. You may remain, Ms. Thompson, but one more outburst and you will be removed. Is that clear? Yes, Your Honor, she whispered, sinking back into her seat. When the hearing concluded 2 hours later, Judge Bennett announced he would issue his ruling within 10 days, but strongly advised the parties to seek mediation in the interim. The look he gave Karen's attorney made it clear which party he believed should be most motivated to settle. As we gathered our documents to leave, I noticed Karen staring at Mom with a mixture of resentment and newfound wariness. Mom met her gaze directly, neither gloating nor intimidated. You knew, Karen said, her voice low. You knew all along who would be presiding today. I knew it would be a fair hearing, Mom replied simply. That's all any plaintiff can ask for. The aftermath of the hearing spread through Oakwood Gardens like wildfire. By evening, everyone knew that quiet Sophia Mitchell was actually Judge Mitchell, that she had methodically documented Karen's pattern of selective enforcement, and most explosively, that she had uncovered serious questions about where HOA dues were really going. Mom's phone rang constantly with calls from neighbors sharing their own HOA horror stories and asking for advice. She listened patiently to each one, jotting notes in the same meticulous hand that had once drafted landmark legal opinions. You're not planning to represent the entire neighborhood, are you? I asked, half joking, after she finished her 12th call of the day. Of course not, she replied, reviewing her notes. But patterns are important in establishing a case, and it seems our experience wasn't unique. 3 days after the hearing, Karen's attorney reached out to propose a settlement. The terms were straightforward. All fines against Mom would be dismissed. The HOA would establish an independent financial review committee, and clear guidelines for bylaw enforcement would be developed with resident input. It's a reasonable start, Mom observed, but it doesn't address the leadership issue or the potentially fraudulent contracts. And she countered with additional terms. Karen and her allied board members would resign. A forensic audit would be conducted by an independent firm, and an interim board would be appointed until new elections could be held. Furthermore, any financial improprieties discovered during the audit would be reported to appropriate authorities. Karen's attorney called the counter-offer excessive and punitive. Mom simply responded that she was prepared to wait for Judge Bennett's ruling if they couldn't reach an agreement. 2 days later, they accepted all her terms. The following week, Karen Thompson and 3 board members submitted their resignations. The 4th member, the nervous man with thinning hair, came forward with additional information about questionable financial practices, apparently hoping to mitigate his own culpability. The forensic auditors arrived the day after, setting up shop in the clubhouse with boxes of financial records. Mom was offered a position on the interim board but declined, suggesting instead that the role should go to someone with accounting expertise, like her friend Olivia. She did, however, agree to chair the committee tasked with revising the HOA bylaws to prevent future abuses. The problem wasn't the existence of rules, she explained during the first committee meeting, attended by nearly 40 residents. Rules provide necessary structure for communal living. The problem was arbitrary enforcement and lack of transparency. Clear rules, fairly applied, protect everyone. Over the next month, The true extent of Karen's financial scheme became clear. Summit Green Landscaping was indeed owned by her brother-in-law and had been charging nearly double the market rate for services. The security company was similarly overpriced and underperforming, with connections to a cousin. In total, the forensic audit identified over $150,000 in questionable expenditures over just 18 months. The county prosecutor's office opened an investigation based on the audit findings. Karen and her husband abruptly put their house on the market and moved to Arizona, leaving their attorney to handle the mounting legal issues. Throughout it all, Mom maintained her characteristic composure, neither gloating over Karen's downfall nor shying away from the work of rebuilding the community's governance structure. She approached the bylaw revisions with the same thoughtful consideration she'd once applied to legal opinions, seeking input from diverse residents and balancing competing interests with remarkable fairness. "You're enjoying this, aren't you?" I asked one evening as she reviewed resident suggestions for the revised pet policy. She looked up, a slight smile playing at her lips. "I've always believed in the power of well-crafted rules to create just communities. It's not so different from my work on the bench, just a smaller jurisdiction." 6 months after what Oakwood Gardens residents now call the reckoning, our community has transformed. The new board, elected in a record turnout special election, operates with unprecedented transparency. Board meetings, once sparsely attended affairs of rubber stamp approvals, now draw dozens of engaged residents. The revised bylaws, which passed with 87% approval, include clear enforcement procedures, robust appeals processes, and strict financial oversight mechanisms. The bird feeder that started it all still stands outside Mom's kitchen window, now joined by several others throughout the community as part of the newly established Backyard Wildlife Certification Program. The once uniform landscaping has given way to thoughtful diversity, native plant gardens, small vegetable plots, and yes, even the occasional decorative gnome. Mom has become something of a local celebrity. Residents stop by with homemade treats and legal questions, which she fields with her characteristic patience and wisdom. 3 times a month, she hosts Coffee with the Judge at the clubhouse, an informal gathering where residents can discuss community issues in a non-adversarial setting. "You've created a whole new career in retirement," I teased her after one particularly well-attended session. "Not a career," she corrected, "a community. There's a difference." The aftermath of Karen's scheme had legal consequences beyond our HOA. The case prompted the state legislature to pass new regulations requiring greater financial transparency from homeowners associations and establishing clearer resident rights. Mom was invited to testify during the legislative hearings, her testimony drawing on both her judicial experience and her recent first-hand encounter with HOA abuse. Karen and her husband ultimately settled the criminal charges with a plea deal, paying substantial restitution and accepting probation terms that prohibited them from serving on any HOA board for 10 years. The story made regional news, with one outlet dubbing it "Gavel of Justice," retired Judge School's HOA tyrant. Mom dismissed the sensational coverage with a wave of her hand. It wasn't about punishing Karen, she insisted. It was about restoring proper governance. On the first anniversary of our move to Oakwood Gardens, Mom hosted a garden party in her backyard, something that would have been impossible under the old regime, which limited gatherings to the clubhouse. Neighbors brought potluck dishes. Children played on the newly installed community playground, which replaced the adults-only meditation garden Karen had championed, and there was a palpable sense of genuine community that had been missing before. As twilight fell and residents lingered over dessert and conversation, Olivia raised her glass in a toast to Judge Mitchell, who reminded us that justice isn't just for courtrooms. Mom blushed slightly at the attention but raised her own glass in return. To Oakwood Gardens, where rules now serve people, not power. Later, as we cleaned up after the last guests had departed, I found Mom standing by her bird feeder, watching a pair of cardinals settle in for the evening. "You know," she said thoughtfully, "your father always told me I'd be bored in retirement, that I'd miss the intellectual challenge of the law. Were you, before all this happened?" She considered the question carefully, as she did all important matters. Not bored exactly, but perhaps underutilized. There's a certain satisfaction in applying a lifetime of knowledge to problems that matter, even small ones. Defending elderly homeowners against tyrannical HOAs wasn't exactly what Dad had in mind for your golden years. I laughed. Perhaps not, she smiled, but I think he would approve of the outcome. Communities, like courtrooms, function best when power is balanced and rules are applied with wisdom and restraint. That's not retirement wisdom. It's simply justice. As the cardinals chirped their evening song, a sound that might never have graced our community under the old regime, I realized that Mom had done more than win a case against an overzealous HOA president. She had created a template for how communities could govern themselves with fairness and transparency. The bird feeders, garden gnomes, and diverse landscaping were just visible symbols of a deeper transformation. In the end, Karen Thompson's biggest mistake wasn't targeting a retired judge with her petty enforcement crusade. It was forgetting that communities are made of people, not rules, and that true leadership serves those people rather than controlling them. Mom had taught that lesson from the bench for decades. Now, in retirement, she had taught it again, one bird feeder at a time.